Numbers 95 and 96, matter of Borelli v. Yonkers and Yonkers v. Yonkers firefighters. Counsel?
Good afternoon, Your Honors. May it please the Court, I respectfully request to reserve 5 minutes for rebuttal.
You have 5 minutes.
Thank you. The term regular salary or wages is not defined in General Municipal Law, Section 207A. Key words came at the end of the Second Department's decision in the Borelli case, where the Court acknowledged that the parties may agree in a collective bargaining agreement to include additional amounts like night differential, check-in pay, and holidays in the regular salary or wages, and it's appropriate for an arbitrator to decide.
And was that given to, I know you're talking about the Borelli case and not the other case right now, but was that given to the arbitrator to decide here?
Yes, so there are two cases, but they are related, as acknowledged in the Borelli decision. So after the Second Department reversed and denied the stay of arbitration, it went to arbitration. Arbitrator J. Siegel construed the collective bargaining agreement and found, the decision is attached to our brief, and found that express provisions of the collective bargaining agreement provide for night differential, check-in pay, and holidays as part of compensation. He cited Article 4, compensation of the collective bargaining agreement, the maintenance of benefits provision, as well as the 207A procedure, which is next to the collective bargaining agreement as Appendix C.
So are you asking us to construe the statute, or you're not asking us to construe the statute?
Well, I think what the statute says, regular salary or wages. So in order to answer that question, whether it's regular salary or wages, it requires the arbitrator to construe the collective bargaining agreement to see if there was an agreement.
That's possible, or the statute might have some extrinsic meaning, right? There's two ways, let me see if I can make it clear. I can imagine two ways that you might approach this. One would be to say, statute says regular salary or wages. That has some defined meaning that the legislature meant, and you should decide what that means. Another way to construe it is to say, the statute says regular salary or wages, and that allows the parties to define that however the way they want, irrespective of whether the legislature thought it meant something. It could be either of those two.
Well, I think when the legislature said regular salary or wages, what they wanted to establish was that a permanently disabled firefighter would receive the same amount of regular salary or wages of an active firefighter on retirement.
Counsel, before you get into the statutory argument, and we can debate the finer points of that, but I don't know if this was something implicit in Judge Wilson's question or not, but do we have to answer that question about what it is under the statute if it's already been decided that it's included as part of the CBA? Do you have to have belts and suspenders here?
I don't think so. I think the court properly deferred to the arbitrator to decide that each case is going to be different.
I'm sorry, just to go on that point again and following up on Judge Wilson. So what did the appellate division decide in Borelli?
Well, the appellate division basically, in my opinion, deferred at the end of that decision, deferred and said that the parties can agree to add compensation to regular salary or wages, and it's for the arbitrator to decide.
But it seems to me they said first, it isn't what you would normally consider under the statutory definition of wages and salary, but you can define it under the CBA, and that's for the arbitrator.
Well, I don't think they said that it's not normally considered. I think that they cited...
We agree with Supreme Court that petitioners did not sustain their burden of establishing their entitlement to the 3 categories of disability pay benefits under the language of 207A2.
I think the court cited some cases that are distinguishable in that the collective bargaining agreements did not cover the types of... What's key in this case, what's really key in this case, is that the night differential and the check-in pay and the holiday pay are paid whether you work it or not. You could be on sick leave. You could be on 207A1. You could be on long-term illness.
So are there firefighters who never work at night who get the night differential?
Yes, and who never check in for a shift.
I'm
get it.
just focusing on the night differential for a moment.
Sure.
Are there actually firefighters who never work a night shift?
Well, you're asking me about active, there are...
Yeah,
fi-
active.
The night differential is paid regardless of the schedule. So,
That's a different question, though, than I think the one Judge Wilson asked. But is it the case that all active firefighters at some point do work a night shift?
not if they're on sick leave, not if they're on 207A1. So you could still be,
Yeah,
you could
I'm
still
not-
be
I'm
an active
trying- so
firefighter. An
let
active
me-
firefighter.
Okay, that's not exactly what I'm asking. So there are schedules in the record that look as if there's a 9-day rotation for all the firefighters, and the night differential is paid if you work one night during a 2-week period. Looking just at the paper record, it would look as if every firefighter, because of the 9-day rotation and the 2-week period that it establishes entitlement to the night differential, everybody is working at least one night somewhere during that 2-week period. But I can't tell if that is in fact true. That's what I'm asking.
I think the schedules vary. I think the schedules vary. And what's really relevant here is that an active firefighter includes firefighters who are on sick leave, who are not working, who are on 207A1, injured in the line of duty and not working, and they are paid those monies. They are
The
paid
ones who are, the
night
ones who are injured, let's say, in a jet ski accident unrelated to work, may or may not get the night differential based on a discretionary determination of the commissioner, right?
No.
No?
No, that's the key point here, is that night differential is paid as part of salary whether you work or not. That's the key. So by not paying it to these permanently disabled firefighters, you're discriminating against them when everyone else gets it. In fact, as a result of the decision in this case and the third department decision, all permanently disabled firefighters after 2015 have received those monies. The only ones that haven't received those monies are the Borelli appellants and petitioners. So you have this subclass who are being treated differently. So whether you work or not, regardless of schedule or status, in Yonkers, firefighters receive these monies, the night differential, the check-in pay, and the holiday pay.
But how does that impact 207A? I mean, aside from the fairness of it, aside from the custom and procedure, how should we analyze it in
so-
terms of 207?
So 207A is a statute that provides that firefighters in New York State who are injured in the line of duty should receive the same salary as firefighters who are active. That's the guiding principle. And it refers to regular salary or wages. And to define that, what's regular salary or wages, you have to look at the facts of the particular case.
That's interesting, because what the appellate division looked at was the body of case law that has grown up around the definition of regular salary or pay. And they said it is the following things. It's annual or base salary, plus increases or possibly decreases, and excluding any unused vacation time and sick time accruing during disability. And that's it.
Yeah, but that's...
Nothing else.
Those were based upon those cases. They did not properly
So you're
refer to
asking
the-
for an expansion of the
I
statutory
don't think so.
definition?
I think the third department in McKay got it right. And basically, this case...
So is it that this case, because of practice, they created the pay as the city created it as regular pay by giving it to people irrespective of what their duties were?
Correct. And in the record, 105 in the 628 case, there's a stipulation. It's a very key stipulation of facts in the case. And that stipulation clearly says that since 1995, and earlier than that, the city has always paid these monies regardless of schedule or status, and that part of salary. You could disagree with it, but that is the practice. And so injured firefighters, permanently injured firefighters under the concept of 207A should be treated the same until they reach their maximum retirement age.
Yeah, but custom can change. An employer can change the custom. So then what happens?
Well-
Like, why not be more explicit in the CBA?
Well, so they tried to change it, and we filed an improper practice charge, and the third department found that the city violated the law by trying to change it, and ruled that there should not be, that these monies are owed, and they should be paid. So right now, the third department, when it wasn't appealed, in that PERB case, on the same subject matter, ruled that these monies should be paid. And so respectfully, I think that you have the third department case, you have the second department, which referred it to arbitration, the Siegel Award, which has been confirmed by Westchester County Supreme Court. The petitioner appellants in Borelli are the subclass who are the only ones who are not getting these monies because they retired prior to 2015. And there's no question, it's stipulated that everyone else, whether they're working or not, if they're on 207A, sick leave, they get these monies. And the statute, the policy behind the statute, and it's a good thing. It's a good thing that firefighters who are permanently injured, that they continue to receive these monies, you know, because of their injuries. They've sacrificed themselves. The record, I think, is clear in that regard, and they shouldn't be treated as second class because of these injuries, which is what happened.
You're saying it's in part an expectational remedy. And this is what they all anticipate, this is what they all
what the law
expect,
s-
and they shouldn't be treated differently.
Yes, but it's the law. The 207A, the legislature, the state of New York has said that firefighters permanently injured should receive the same regular salary as active firefighters.
Thank you,
And-
counsel.
Thank you.
Good afternoon, Your Honors. Paul Sweeney of Coughlin Gearhart on behalf of the City of Yonkers. Your Honor, if I could reserve 5 minutes for rebuttal.
It's not generally the case, rebuttal for the respondent. Is it for the second appeal?
Yes, Your Honor.
Yes.
In case I need it, I may not need it, obviously. Your Honor, in response to questions to counsel, this court, since 1982, has indicated that there is a methodology to analyze the issue at hand, and you have to look at the CBA. This court, has never said you look at the past practice of the parties to determine that.
Counsel, is it your view, we've been kind of debating this here, I think, that the statutory term, regular wages and salary wages, that has a meaning, a core meaning, and that if you want something beyond that heartland meaning, and I think Acting Chief gave that definition, you need to expressly provide it in the CBA.
Yes, Your Honor, that is what Chalachan, this court's decision says. That's what this court said in Coho's 2002 case. And I use the words throughout the brief of expressly provided for, because this court has consistently said that if you want to give something beyond regular salary and wages, you have to expressly provide that in the
So
contract.
where do we find the definition of regular salary and wages outside of a CBA?
Well, Farber, Your Honor, this court's decision from 2002 as well says it's used the words current salary at the time of retirement. But in terms
But
of...
isn't that the CBA then? Isn't that kind of circular?
Well, Your Honor, I'm happy to live within the world of the CBA because as this court knows, if you look at Article 4, it actually defines what base salary is. And to your point, Your Honor, it says it will be the base salary plus longevity. That's in Article 4.
But then you're really, I think, saying that, you know, the two options I provided, that it's the second, that is the term in the statute, regular salary or wages, has no meaning independent of the collective bargaining agreement. It's whatever the parties agree to in the way of the collective bargaining agreement. Is that what you're saying?
Yes, Your Honor, not defined in the statute, not defined in the legislative history.
So to put a point on it, so that the parties could agree that regular salary and wages is $1 in the collective bargaining agreement, and then say we're also going to make discretionary payments to everybody in the amount of $100,000 a year, and that would not fit within the statutory definition.
Correct, Your Honor, but to be more particular, in Coho's, this court was faced with an issue where certain fringe benefits were expressed to be provided for as a 207A2 benefit, including holiday pay. And this court said because other benefits were not, and some were, then obviously the parties had negotiated to provide certain benefits. Here, it's undisputed that check and pay, night diff, holiday pay are not included as a 207A2 benefit.
But then it brings me back to the question I asked your adversary here. What did the appellate division decide here?
Your Honor, it's interesting. In Borelli,
In Borelli, I'm sorry.
In Borelli, the appellate division followed this court's case law and other case law throughout the Second Department and other places, and said, the city had a rational basis for denying the expansion of A2 benefits to the retirees for these three categories.
But it seemed almost to be saying, and I may be misreading it, that this doesn't qualify, going back to Judge Wilson's point, these three categories don't qualify as regular salary and wages under the statute. If you want them to be regular salary and wages, you have to look to the CBA and do it there, and they deferred to the arbitrator, which seems to say that there is some ideal regular salary and wages definition or heartland definition that these were not part of. But I'm not entirely clear on if that's what they were doing.
Well, Your Honor, despite the ambiguity that might be in this record, the CBA is explicit as to what base salary is. There's definitional sections, including the rate of pay. The rate of pay, a daily rate would be 232nd of the annual salary, which includes the base plus longevity. It excludes all of these other pays, including arson pay, night diff, holiday pay, check-in pay. And Your Honor, there's a reference to an arbitration award from J. Siegel. The city is moving to vacate that for the same reasons that I'm here before you, that Mr. Siegel had no lawful ability to issue an award which expanded the CBA.
Are the three special pays in fact paid to everybody?
Your Honor, I think it's undisputed by practice, the city for some time through an erroneous payment was paying these special pays to essentially all firefighters.
Including the night diff?
Including night diff.
Okay.
And that, not right, that happened. But again, it's not a past practice issue because that's not what this court said. This court said, look to the language of the CBA.
To go back to the question Judge Wilson asked your adversary earlier, is it the case that all actively working firefighters who receive night diff work nights, or do you get night diff even if your schedule doesn't have night duty?
Your Honor, I believe, and it's not clear in the record, I believe you could have a onesie and twosie where you have somebody that, as Mr. Carnthal indicated, that is like on 207A1 where they're sitting home and they're getting a night diff payment. You could have the union president who's on release time, who doesn't work at the firehouse. I'm pretty sure he gets night diff. So unfortunately, I think as a matter of practice,
Everybody gets it.
a lot of people got paid night diff. And Your Honor, the flip side of that is if you look at the actual language of the CBA, there are terms and conditions that tie to it. You have to work at night. You have to check in.
What happens if you don't check in?
I think you still get your check and pay, Judge. And again, that's by practice, and Attorney Carnthal mentioned PERB. Interesting fact, PERB has no jurisdiction to interpret contract disputes.
So the fact that everybody's getting it, whether they do extra work or whether they do check-in or not, it doesn't mean anything. It's just discretionary extra pay that you're giving?
Your Honor, what I would say is that there's evidence of a practice of making these payments, say, over 40 years in error. What I'm also saying is there's clear, unambiguous contract language which should control and what this court looked at.
Isn't there a provision of the contract that protects against diminutions or reductions of payments that are made by custom?
Yes, Your Honor. There's a maintenance of benefits provision at Article 31,
No.
but actually that article supports my position because it's a catch-all provision which says those benefits or those understandings which are not explicitly set forth are protected. Well, that means we're talking about implicit expansions of a contract, and that's not what this court held.
Well, it's explicit in the Article 31.
Well, Your Honor, Article 31 is it is a catch-all paragraph which...
But it's something that you agreed to.
Well, Your Honor, it goes to a past practice argument, and again, unless this court wants to develop a different rule, you have to look at the express language of the contract.
I guess that's what I'm struggling with a little bit. At least a way to read Article 31 is that you expressly agreed that if there was a benefit that was paid that is not included in the collective bargaining agreement, because that's one of the conditions in Article 31, that was paid to people as a matter of customer practice, that you agreed you wouldn't diminish that.
That's what Article 31 says, Your Honor.
Yeah.
And I would, and Your Honor, in Cohoes, which had a broad arbitration clause, much like the one here, this court
It
said that,
didn't have a provision like Article 31, did it?
I don't believe Cohoes it was not about a maintenance of benefits issue, Your Honor. But I guess my point is the maintenance of benefits provision talks about a past practice type of theory, and that would fly in the face of what this court has done in Chalichan and.
Well, no, I'm not
Cohoes.
sure about that, because those cases say if you didn't have a contractual agreement, then you wouldn't look to a past practice. But if you have a contractual provision in which you're agreeing to a past practice, that seems to me different.
Your Honor, and I would respectfully point out that in Cohoes, this court said the fact that we're talking about holiday pay among other defined benefits, that's express. And the fact that the union in Cohoes wanted other benefits added is they said, this court said we can't go that far. Notwithstanding Article 31, there is no express provision in this contract which makes those 3 special pays part of a 207A2 benefit. And that's what this court has held for the last 40 years is sufficient for the appellate division to have denied.
So then what does Article 31 do? What's the benefit they got for negotiating that?
Well, in a different context, Your Honor, in a different dispute, Article 31 may be relevant for a case that should go to arbitration. It's the city's position that this case should never have gone to arbitration, and therefore the maintenance of benefit provision would never kick in.
What about Appendix C, which is sort of 6 pages of rules governing arbitration of 207A disputes?
Your Honor, 207, that 207A appendix, that procedure, that negotiated procedure, makes no reference to special pays being part of this statutory benefit, and I think that's significant.
Doesn't exclude them, though, specifically.
It's silent, Your Honor, doesn't mention it, and based on Cohoes and other cases, that doesn't err to the favor of the union. That actually would support the city's position that there's no express provision making those special pays as part of a 207A benefit. So I think that actually supports the city's position.
Thank you, counsel.
Thank you, Your Honor.
The Cohoes case, I believe, dealt with light duty. It did not address the specific issue here in dealing with General Municipal Law 207A2 regular salary. I think the record in that case is clear that there were no provisions in the collective bargaining agreement relating to the subject. I think this case, based upon the record here, which is that we have a collective bargaining agreement that has an Article 4 compensation that the arbitrator cited, that listed as part of compensation the 3 types of payments that we're talking about. The maintenance of benefits provision, which he cited as a very strong provision with a stipulated past practice going for years. It's undisputed, as counsel acknowledges. And the 207A procedure, which was not in these other cases. So the 628 contract has many provisions that the arbitrator relied upon and cited. In finding, he found that it was a violation of the collective bargaining agreement and that these payments, the night differential, check-in pay, and holiday pay, are to be paid under 207A2.
But that award isn't before us, right? The only arbitration issue I thought that's before us on this appeal is whether it should have gone to an arbitrator or not.
Well, you know, Your Honor, it's interesting because I started out the oral argument by citing the last words of the Second Department's Borelli decision, where they deferred. They said, yes, we can't give an opinion here, but it's for the arbitrator to decide. And so we have an arbitration decision. I don't think it's right to just now re-argue that arbitration case here. The arbitrator decided, and it's been confirmed.
I assume we agree with that, or assume I agree with that anyway, but you're still standing up here and you're asking us to do something with the Borelli decision, and I am not entirely clear what that is, because my view of the decision is that they are only talking about the statutory definition of regular base pay under 207A. You have your contractual argument. It actually went to an arbitrator. It broke your way. The resolution was that it is part of the contractual base salary. So what are we reviewing
So
here?
Your Honor, what you're reviewing And I ask that you look at that stipulation, because I worked on that stipulation, and it's in the record of these cases, both these cases. You have a stipulation with the city of Yonkers agreeing in writing. It says regular salary or wages includes night differential, check and pay, and holiday pay, whether it's worked or not. They've agreed to it. And so this is, to me, pretty straightforward.
So what would happen if we disagree with the arbitrator in terms of the interpretation of the contract? What's the result here?
Well, that case is, there's a decision by Judge Giacomo in Westchester County. I think it's on appeal. That's going to take its course.
So we can't disagree now, here, is that
No,
what
but
you're
let's say
saying?
we have Borelli, we look at Borelli and we say, okay, for the Borelli petitioners, we're going to interpret the CBA because we think that the statute refers you to the CBA. We look at the CBA, we come out differently. We say, no, under the CBA, this isn't, I'm just hypothetical. We say, no, this isn't regular salary, wages and salary.
I think the second department in the Borelli decision basically said, we're going to defer to the arbitrator who has the power to decide the contract. And the arbitrator decided. And the second department in the 628 case said that the arbitrator has the authority to do it. It's not against public policy, that the subject matter is reasonably related.
If we affirm in Borelli, you then get what you want, because all we're doing is affirming the appellate division.
Well,
saying
no,
you're deferring
because-
to the arbitrator.
Well, the parties are different because the
No, but your
petitioner's
position
appellants.
your position is the appellate division deferred to the arbitrator in Borelli. So if we affirm the appellate division, we are then doing what the appellate division.
I think the decision is that the second department got it wrong in that they applied construed the term regular salary or wages too narrowly, not considering the facts and the stipulation of the record. Here, we have payments as part of regular salary wages that are paid to active firefighters, whether they're working it or not. That is the controlling legal principle. And the second department went astray.
But if
They-
the
At
second
the end of the
department's
decision, they
really-
gave us some benefit of
If they're
agreeing.
really just saying this doesn't qualify under the statute, you can look to the CBA, we defer to the arbitrator on the CBA, wouldn't then, if we affirm that, be saying the same thing?
Well, as I'm standing here and I'm trying to put myself in your place, I would say remand it. I would say remand to the second department to reconsider the decision in light of the second department decision and the arbitrator's decision.
So because the arbitrator found that the special pays were part of regular base salary, that would be a basis for the appellate division to reconsider its legal determination that they're not part of the statutory definition?
No, I think a remand the second department should reconsider its decision because I think it gave a much too narrow definition of
Regular base pay.
of regular salary or wages, and it should be remanded for reconsideration of that. That's what I think.
Okay, thank you, counsel.
Thank you.
Your Honor, briefly, as a counsel pointed out, the Borelli decision and the motion to stay arbitration are actually involved two different groups of people. The 44 retirees is part of Borelli, active firefighters are part of the motion to stay arbitration, so it's really not the same issue. And to your point, Your Honor, I believe the appellate division got it right in Borelli because they cited the same case law that we've been talking about today. In the motion to stay arbitration, they ignored this court's case law. They didn't even refer to it because they couldn't refer to it and still refer this matter or let this matter go to arbitration.
So just so I'm clear, please help me. If we were to affirm the appellate division in Borelli, who loses? Because, you know, the retirees are still going to get their benefit under the contractual arbitrator decision, aren't they?
No, Your Honor. The 44 retirees in Borelli are not part of that arbitration proceeding. So
So that's who loses, the retirees.
yes, Your Honor, the retirees that are part of the Borelli class would be affected by this. However, Your Honor, we are moving to vacate the arbitration award that's been referred here for the same reasons that I'm here today. It was a improper expansion of the CBA beyond what this court would permit in Chalachan and,
Are you arguing that we can do that now?
no, Your Honor. I believe it has to run its course.
That's what Judge Garcia's question, I think, goes to, right? The circumstance where the arbitrator has already construed the entitlement for the current employees a certain way based on either the reading of the statute or the collective bargaining agreement. And were we here to have a different reading in the case involving the retirees, the first thing you would do is to take that decision on appeal and say, the Court of Appeals has construed this in a way different from the arbitrator, and therefore you ought to vacate it, right?
Yes, Your Honor.
I mean, that's what I would do if I were you.
If that issue is before you, I mean, obviously, the appellate division, for whatever reason, on the same day, issued two different decisions where it acknowledged this court's case law in one case, Borelli, and ignored the case law in the motion stay arbitration. And I think they had to do that in order to get the result that they wanted.
Thank you.
Thank you, Your Honor.
I'm sorry, counsel, I'm sorry.
Come back before it's too late.
Sorry, almost. What was the dispute that was arbitrated?
Whether or not the active duty firefighters.
Right, I know the parties there, but it seems to me part of that, and it's not entirely clear to me, at least from the appellate division decision on that part of the case, but part of it was you were paying, the city was paying these benefits and stopped.
Yes.
And could you stop paying these benefits? Is that a different question than were you originally entitled to these as wages and benefits under this CBA?
I think, Your Honor, that they're linked, meaning that the city had a good faith basis to stop, they were overpaying these benefits, and therefore they terminated the payment of these benefits. And to be clear, we were never talking about 207A1 benefits, which are for active duty firefighters. We've always been talking in Borelli and in an motion stay arbitration about 207A2 benefits for retired firefighters.
Would you say, it's fair to say that you have to answer the question about whether they're part of base pay in order to answer the question about whether the city rightfully decided to suspend those payments?
Yes, Your Honor. I think you have to do an analysis of the CBA.
You can't answer one without
You
answering
can't
the
say
other.
customs and practice is enough to...
Your Honor, I don't see anywhere where custom and practice has ever been a factor for this court. This court has consistently looked at the strict construction of that CBA to interpret it.
Unless you've negotiated that you're going to honor custom and practice.
Your Honor, I would not be standing before you if if the CBA was different and said the following special pays are part of the 207A2 benefit, or the city will continue to honor the practice of paying 207A2 benefits, which include the following. We don't have that fact pattern here.
Thank you.
Thank you.
Thank you, Your Honor.